appeared here earlier today?
I think
you
so.
look familiar. Please proceed.
Good afternoon, Your Honors. Tim Boffman, Assistant Prosecuting Attorney, representing Kim Worthy, the Wayne County Prosecutor. The court requested supplemental briefing on several issues in this case. The first is a factual issue, whether the defendant was accurately advised at the plea of lifetime electronic monitoring, and the short answer to that is no. He was not told of lifetime electronic monitoring at the plea. Of course, the plea was taken 3.5 years before this court's decision in Cole, and the court followed the then existing court rule, so it's not surprising, I don't think, that the judge did not mention it, but he didn't. A point I'll return to in terms of prejudice, the defendant was told of electronic lifetime monitoring at sentencing. Moreover, in the pre-sentence report in 2 places, including under evaluation and plan, the report said lifetime electronic monitoring is to be ordered as a condition of parole, and defendant and his attorney said at sentencing that they had gone over the pre-sentence report. The lurking in this case is the issue argued a little bit ago in the Comer case with MCL 750.520N. The defendant in this case, the victim was not under the age of 13, so if the court decides in Comer that he's not subject to lifetime electronic monitoring, if you come out that way, that CSC1 is not an automatic lifetime electronic monitoring, then the defendant in this case didn't have to be told about lifetime electronic monitoring. But it's been made a condition of his sentence some years down the road, he's still in prison, and that would need to be stricken. So that's lurking in the background. If the court decides, however, that he is subject to lifetime electronic monitoring and that all CSC1s are subject to lifetime electronic monitoring, then the defendant wasn't told, and this court has asked whether or not on a motion for relief from judgment, what does the defendant have to do to show prejudice in that context. The court rule says that the defendant has to show...
Does it matter, though, in your eyes, that you indicated that he was told of the lifetime electronic monitoring, but he was told of lifetime electronic monitoring as the sentence was being completed, as it was being handed down, not he found out about it like at the end of the proceeding? I mean, in a way, that could be a little bit of a surprise.
Well, the judge told him about that then. As I said, it was also in the pre-sentence report that he and his attorney said they had gone over that afternoon. So in the context of a motion for relief from judgment, this is not a direct appeal. On a direct appeal, it might be different. Prejudice component on a motion for relief from judgment is different, and you look at the totality, including the plea, the sentencing, the fact there was no motion to withdraw. All that goes into the question of whether or not, under the court rule, the plea, as this court's rule says, whether or not the defect in the pleadings was such that it rendered the plea not involuntary to a degree that it would be manifestly unjust to allow the conviction to stand. So you need to look at the totality for that, and one of the things the court has asked is, under the circumstances, would defendant have to show, in order to show prejudice, should he show that there was a reasonable probability that had he been informed at the plea, he would have not taken the plea. The court cited in its order the Temrec case from the United States Supreme Court, which is very similar. In Temrec, the defendant was attacking his plea on collateral attack, as in this case, and he was not told that he was subject to special parole. Special parole in the federal system is a part of the sentence. It's a direct consequence. He is sentenced to special parole of at least 3 years. In fact, he got 5 years of special parole.
So
he wasn't told that.
But what would the general approach be to this? Lifetime electronic monitoring, it's part of the original sentence, and
yes.
You know, you guys spend a lot of time kind of in your briefs talking about the fact that, you know, this was a really good deal for the defendant. So, you know, but ultimately, if you were to have a situation where the defendant basically says, you know, look, like, what would be wrong in this case? You know, if you were to send this back down for an evidentiary hearing to determine what the effect of this would be, you know, how significant this is. Lifetime electronic monitoring is a pretty significant thing, is it not?
It is, and the life without parole on numerous counts that the prosecution forewent is also a fairly serious consequence. This was, so I use a vernacular, a fairly sweet deal because there were children involved in multiple counts of rather
4 counts, four victims were not even charged.
4 were not even charged, and I believe it was 13 counts that were foregone, and that would be resurrected if it came back. And those are part of what you look at in terms of whether or not he would have taken the plea.
What's the standard for determining?
Well, the standard, Timrek said that the standard is, and it's a fairly general, the language is fairly general, that it has to be that
How do you establish that the plea is involuntary to a degree that would be manifestly unjust to allow the conviction to stand?
Well, I think you used both the language of Timrek and cases that followed it. Timrek says we're not going to reverse a plea, and there's special finality with regard to pleas unless it can, we would find what they called a complete miscarriage of justice or a proceeding inconsistent with the rudimentary demands of fair procedure. So it can't be just any error that would result in relief on direct appeal. It has to be something of that context, and I think that if you look to the federal cases that follow up on Timrek on both collateral attack and on plain error review, they apply plain error review to the failure to inform of a sentence consequence, and they look again holistically, and there are cases that have specifically denied relief on the ground, in large part, that the information regarding sentence was contained in the pre-sentence report, which the defendant confirmed that he had understood during the plea colloquy. That's exactly from a federal opinion saying he doesn't get any relief because that's the case. And they also look to, as I said, whether or not there was a reasonable probability that the defendant would not have taken the plea, which is something this court cited in its order. And the factors, Justice Young, that the court looks to is, and the court can do this on the existing record, I think, whether or not the defendant obtained a benefit in the form of more lenient sentencing. Yes, he did. Whether he advanced any basis for doubting the prosecution's case. He hasn't. Didn't and hasn't. Whether the prosecution would have been free to prosecute him on other counts, in addition to which he pled guilty. It certainly was. In fact, the prosecution would have been free to pursue other cases other than those that were forewent. The defendant here, as the court knows, pled guilty with a sentence agreement of 14 to 25 and 10 to 20. He faced life with a total of 15 counts, and the prosecution agreed to forego 4 other cases, as Justice Young has pointed out. In this context, it cannot be said.
Should we be doing that analysis here, or should we remand it to the trial court if we agree with
You can remand it to the trial court, but the record is the record, and the defendant never, frankly, it never said. It's been said that he said in his motion for relief from judgment that he wasn't informed of lifetime electronic monitoring. I've read it, and the judge addressed that. I keep reading his motion for relief from judgment, and all I see him saying is I wasn't subject to lifetime electronic monitoring under People v. Bowman, the unpublished opinion. He didn't say I wasn't aware of it until his application for leave to appeal. So I think in that context, this court can rule on the record, or remand it to the Court of Appeals, and say for the Court of Appeals to do the analysis.
Well, he's never said I wouldn't have pled had I known. Has he?
I don't think so. He might have said it in his application for leave. He did not say.
Not in his original motion.
Not in the original motion. In the original motion, he didn't say I wasn't informed. He said I shouldn't have been given the sentence. I shouldn't have been given lifetime electronic monitoring to see People v. Bowman.
So can I go back for a second to, and this, the answer might be your question is irrelevant, and so stop asking. And that's fine if that's the answer. But every time I try and wrap my head around the procedural mess that is this case, I get confused. And now it's late in the day, so I need you to help me. So the first time this court had his application, should we have given him his direct appeal back? Do you think his appellate attorney was ineffective for not filing a leave application and asking the Court of Appeals to remand it, where the remedy would have been he gets his direct appeal back?
Well, if that would have been the remedy, the court said in its order that it was the defendant's default that caused him to.
It's the defendant's fault that he didn't get the attorney assigned in time to automatically file a motion. But when the attorney was assigned on June 25th, he could have filed a leave application, and in the process of filing a leave application, he could have said to the Court of Appeals.
I may have the facts wrong, but I thought the defendant filed very late, and the attorney was therefore appointed outside of the 6 months.
I think that's right, or at least I think they concede that. So
And he
let's
was-
go with that.
So once you're outside the 6 months, this court said in its order that the defendant had forfeited right to consideration under direct appeal. Now, if the court
But
now...
I'm asking if we got that wrong, and if we did, does it matter?
Well, if you got that wrong, I prepared, based on the order that the court issued, that we're considering motion for
I
relief
know,
from
but I assume
judgment.
you read their brief, and the last section of their brief was, you didn't appoint us in time to file a motion for reconsideration to tell you guys that you got that
Well,
wrong.
again, that's a different issue than the court-ordered brief, but in any event...
But you're a master
Just,
of
you're
your...
Tim Hoffman, so I thought I could
If-
ask
if-
you.
if
I
you-
don't know if you're
if
like,
you
all of a
look to
sudden
my
you can't
brief-
answer, then that's okay.
But isn't the answer to Justice McCormick's question that argument is foreclosed by the law of the case doctrine?
That's what I'm asking. Is that foreclosed by the law of the case if we screwed it up?
Well, I would have thought so, but in any
This was
event...
decided against the defendant by this court in an earlier proceeding in this case.
And that's why if...
So right or wrong,
So the initial question is counsel ineffective. If he didn't have a right to counsel, counsel can't be ineffective. You can only have ineffective counsel under the Sixth Amendment if he had a right to counsel. Counsel on a motion for relief from judgment cannot be ineffective. You have to have a right, because that's a...
Well, I understand that well, yeah.
So the question becomes, did he have a right? This court had said in its earlier order he didn't. But let me just conclude by saying if he did, in the cases are cited in my brief, it's still a plain error review, and the plain error review, and the federal cases look at it the same way. Take the Timrek situation. You didn't inform him of a sentence consequence. The question is there still a reasonable probability that he wouldn't have pled if he had been correctly
No,
informed?
that's if that was if the trial counsel, I mean, if you agree appellate counsel was ineffective for not filing a leave application and then a motion to remand,
Okay,
that would have resulted in a direct appeal.
Then you'd be under plain error review,
Okay.
and he'd still lose. You'd still
So
be
if
applying the
this
test.
issue on plain error review, he'd still lose. Okay,
You'd
that's
still
what I
be
wanted to
applying the
get to.
test of is there a reasonable
was where I was trying to
probability
get
that he
to.
would have with not pled if he hadn't given any information. And the factors I just went through, I think the answer is no, and then this court can answer it. Can have the Court of Appeals do it, can have the trial court do it. But I think the record doesn't change, and the defendant standing up and saying, hey, I wouldn't have, doesn't change these facts. Thank you very much.
Thank you.
Good afternoon, Jacqueline Ouvry from the State Appellate Defender Office, again with Ms. Jacqueline McCann, appearing on behalf of Mr. Roark. I want to begin by answering Justice McCormick's question, whether or not this case should be reviewed on direct appeal and whether or not law of the case should dictate the answer to that question. And the answer is no. It should not be dictated by law of the case because that the issue of whether or not this should be on direct appeal was not briefed the first time this court decided the issue. This is the court that decided the issue. And appellate counsel, State Appellate Defender Office, was appointed outside the time for asking for reconsideration within this court. The facts are that Mr. Roark did request counsel late, but he requested counsel within the time for direct appeal. The Wayne County Circuit Court then delayed the time to appoint counsel by more than a month. And counsel was appointed outside of the 6 months, but within the time to file a 42-day leave application, which is under Court Rule 7.2054. And part of that leave application could have been a request to remand, which would have allowed for the trial court to first consider whether or not a motion for plea withdrawal should be granted, and a motion for plea withdrawal on this issue should be granted because it's not subject to plain error review. As this court decided in Cole, this is one of the issues reserved in MCR 6.302 that the court must advise. It's subject to automatic reversal if the advice is not given. So had counsel during direct appeal filed the leave application and the Court of Appeals remanded for the motion for plea withdrawal, the trial court would have been required to grant the motion for plea withdrawal.
Okay, now, assuming, I'm sorry, you were still on your thing, but.
Please.
But assuming we just botched that and we got that wrong, why is that not law of the case that now we are, have to abide by and deal with, we are where we are?
Because you are the court that decided the issue. You did not have briefing on that issue. counsel didn't have the opportunity to ask for reconsideration. The issue was raised in the Court of Appeals.
Why is it that counsel couldn't have asked for reconsideration?
Mr. Roark didn't have counsel after appellate counsel was removed by this court in its order. State Appellate Defender Office was appointed outside the time to ask for reconsideration of whether or not this would be considered under.
And why is that? Why was Sato appointed late?
That was our fault.
Because, is that our fault or is that his fault?
Sato was appointed late. This court did not appoint Sato. This court remanded for the appointment of counsel, and that happened outside the period for reconsideration.
Okay. So we could, though, I'm sorry.
No, go ahead.
So appellate counsel, who was appointed late, but still within the time limit, the 42 days, could have filed the motion that you suggested, but then, and failed to. So we could have framed, you could frame this entire case, and I believe it was framed below as an ineffective assistance case, right? And the Court of Appeals didn't reach the ineffective assistance claim because they decided it on the voluntariness of the plea. But if you'd framed it as an ineffective assistance claim, then you'd have to prove basically the prejudice prong that Mr. Boffman is saying you have to prove now. So why would it be that if you could frame a claim two different ways, and it's the same claim essentially, the prejudice standard should be less if you frame it one way than if you frame it the other way?
There are two different ineffective assistance of counsel claims. The first ineffective assistance of counsel claim relates to the loss of the direct appeal.
Okay.
And the loss of the direct appeal is
Okay, right, okay. I'm with you. I'm with you on that. And
Okay.
so he could have brought an ineffective assistance claim there and then probably would have gotten automatic relief because of our Cole opinion, but he didn't. So now we're looking at the other ineffective assistance claim.
I thought he only brought that one. This is the part where I'm trying to get, I thought the
Okay.
only claim he originally
Maybe you
brought
should clear
was,
us up.
my appellate lawyer was ineffective, so I need a new.
So the Court of Appeals couldn't determine the ineffective assistance of counsel claim because of the order from this court, because this court remanded under 6500.
Okay.
The allegation is that it was error to remand under 6500 because this court has previously, when ineffective assistance of counsel denies direct review, has remanded as on direct.
Okay.
As on direct, had that been the order from this court, then the issue before the Court of Appeals would not have been ineffective assistance of counsel. This court would have decided that. The issue then solely is whether or not he got the advice. He didn't receive the advice. Under Cole, that's reversible.
Okay.
And so there was a second concern of ineffective assistance of counsel. Did I clear that?
No, I didn't. I was just trying to, there are a number of, I feel like there are also probably a number of ineffective assistance of trial counsel claims, but none of them were in the defendant's original motion. I understand you guys pled some of them when we remanded the case and asked you to fix it. But I don't know what to do with those because they weren't in the original motion. So they feel problematic.
So the issue before this court is whether or not Mr. Roark should be on direct review. And then additionally, if Mr. Roark's issue is not considered on direct review, has he satisfied the prejudice requirements of 6500? Right. So the answer is he has satisfied the prejudice requirements of 6500. The Court of Appeals is correct that the consequence of lifetime electronic monitoring is so severe that the absence of any record of knowledge of this consequence is manifestly unjust to render the plea involuntary.
Well, is that because it's so severe, or would that be any misinformation? So, like, let's say the trial court had said, your sentence is 21 days, and, well, that would be ridiculous. It's 1 year and 1 day, but it's really 1 year and 2 days. So that was the error. He wasn't told that his actual sentencing possibilities was 1 year and 2 days rather than 1 year and 1 day. then you'd still say he was entitled automatically to withdraw his plea? Or is it only because lifetime electronic monitoring is a very serious consequence and greater than the difference between, 1 year and 1 day and 1 year and 2 days?
It's the latter. Lifetime electronic monitoring is so severe. It's one of the rare consequences that is in our court rule 6.302 that the court must advise the defendant of and assess his understanding of the consequence in order to determine the voluntariness of the plea.
Well, doesn't the court have to inform the defendant of all actual sentencing possibilities in order to make sure that the plea is voluntary?
The court does not have to inform the defendant of all possible consequences. There are some that are reserved in 6.302 that involves the nature of the offense and the maximum penalty and any mandatory minimum.
Right, the maximum penalty. So
yes.
If the maximum penalty in my hypothetical is 1 year and 2 days, and I am the court and I say it's 1 year and 1 day, I have not fulfilled that obligation, right? And so I'm wondering whether, does your argument apply only because you somehow think that lifetime electronic monitoring is different in its severity or different in kind than any other discrepancy in what the judge says the maximum sentence is and what the actual sentence really is?
So it is different in kind, and it is because the maximum penalty is treated differently under our jurisprudence as well as under the federal jurisprudence. So the first part, it is different in kind because it is a penalty that lasts until death, because it is a GPS tether which is attached to a person's body and tracks their movements and has been determined to be a search.
So I understand that it's serious, but I just don't know if you're asking us to draw a line based on serious. I just don't know where's the line of serious. What's serious? So if I'm misinformed about the sentence and the judge understates the maximum penalty by 5 years, is that the equivalent of failing to tell me about lifetime electronic monitoring? 1 year, 30 days? I don't, what's the line? Help me with that.
So the answer to the question is yes, that the maximum penalty is special because it is the extent of the state's jurisdiction.
So your answer to my question is any time the judge fails to inform the defendant accurately about the maximum penalty when the defendant is entering a guilty plea, automatic reversal is required even if we're on a 6500 motion. That is always it renders the plea involuntary to such an extent that it works a manifest injustice.
Yes, and the federal cases have made that exception for the maximum and for the nature of the offense. It's different from Timrick and Williams because the maximum is direct. It's not a collateral parole consequence. It's not discretionary.
Well, but in the federal system, under Federal Rule 11, which governs pleas in the federal system, if the judge doesn't strictly comply with Rule 11, they use a harmless error analysis even on direct appeal. So the federal rule is less defendant-friendly than our rule. We have a different rule. But they would apply harmless error analysis even on direct appeal. So it can't be, or one would not infer, that the federal courts believe that the Constitution dictates that a plea is always involuntary and that relief must be granted in the form of the option to withdraw every time the defendant is misinformed.
No, it's not always, and it's not every time. What the federal rules have looked to is the nature of the error, and certain errors are treated differently. And particularly in King v. Dutton, cited in my brief, there the court made a distinction between a maximum penalty in the case in front of it and a maximum penalty in a separate case. And there, they applied harmless error when the maximum penalty was different in the collateral case, the separate case. But for a maximum penalty on the case before the court, that is a separate type of error that is of a structural nature, that is distinct and different, such as the nature of the offense. Also being informed of the elements of the offense is one of those exceptions to the harmless error analysis.
Can I just ask about the end game here? Is it the end game to have this plea withdrawn so that you can have a trial?
So the relief that Mr. Roark has asked for is the relief under 6.310, which is an opportunity to withdraw the plea. So it's a hearing in the trial court where he would be given the advice. He would be able to determine whether or not.
Doesn't he have to at least establish the prejudice here, say that he would not have undertaken the plea had he known?
So when the answer is no, because it depends on the nature of the error, and that is how.
Well, the error is I should have been informed that I'd have lifetime tethering. I wasn't told that, and if the fact is he got such a sweet deal that lifetime tethering wasn't a deterrent to him accepting the plea, there is no harm within the meaning of this rule. Isn't that right?
No, that's.
How is it the plea so erroneous to the degree that it would be manifestly unjust to allow the conviction to stand if there would be no change in his plea, if he had been properly informed? Not just any violation, but to a degree that would be manifestly unjust.
So that goes to the test that the Court of Appeals applied in the Mosley case, and whether or not there are certain violations where that additional showing must occur.
I don't even understand why you need an addition. Don't you have to have a threshold showing that my conviction is to a degree so manifestly unjust that it cannot stand? Don't I have to demonstrate I would have opted for some other alternative than to plea?
Your Honor, I would disagree that it's a threshold showing.
Why?
Because that's not how the jurisprudence has treated the analysis. It's whether or not
jurisprudence?
Our jurisprudence and the federal jurisprudence.
Well, okay. Well, I get to affect our jurisprudence. Tell me why, as a policy matter, that isn't the approach I've suggested isn't the most logical one when you're trying to dislodge a plea. If it's involuntary, I understand it, but it isn't involuntary if you were informed and you still would have made the same plea.
So it's not threshold because there are certain exceptions where the involuntariness comes from the absence of the advice, because it goes to whether or not the waiver itself was knowing and voluntary.
Well, no, let's assume for the purpose of this, it wasn't told, didn't know. Now he knows. Doesn't he have to say, if I'd known that, boy, I wouldn't have made that plea? That then establishes why the plea is so involuntary and to a degree that would be manifestly unjust to keep it in place.
So it's not a threshold showing, Your Honor. For rare exceptions, for jury trial rights, the nature of the offense, and the maximum, the first determination is whether or not it's involuntary, and then it's whether or not there's any indicia that there was some other indication of knowing, some other indication that there was voluntariness there. So it's first whether or not it was involuntary, and then whether or not there's some other indication of voluntariness. And that's how the Court of Appeals addressed the jury trial waiver in Mosley, which was a 6500 case. And that's the correct analysis here, that there are some errors limited to jury trial rights the nature of the offense, and the maximum that are so severe that it's not a threshold showing. The first question is whether or not the absence of the advice makes the waiver involuntary. The answer in this case is yes. There's not any additional record that Mr. Roark had knowledge. This is distinguishable from the Mosley case because...
But that would be a matter that the trial court would determine as to whether it was or was not.
Yes, the trial court can make that determination. This court can remand for that. There's nothing in this record to suggest that Mr. Roark had any knowledge prior to the time of the plea, which makes...
Including, was Mr. Boffman's suggestion that it was in the
PSI.
PSI, thank you. That's not true?
That was not pre-plea, which is what I'm arguing to this court.
It wasn't pre-plea. Pre-sentence, but not pre-plea.
Correct.
Gotcha, thank you.
Okay. Thank you, Your
Ms.
Honors.
Avery. Okay, thank you. You have no more time, I believe. Yeah, thank you. Okay, next case.